Good evening, everybody. Welcome to week 5 of Torts. Time is flying by. It's hard to imagine that we're about a third of the way through our work together this fall until we look back and consider how much we've actually covered up to this point. This evening, the topic on the table is going to be negligence, just like it was for much of last week and just like it's going to be for the next couple of weeks at least. But before we get into negligence again today, I want to briefly summarize a couple of the things that we've gone over before. In particular, I want to focus briefly on privileges, and then I want to review again briefly what we did last week in negligence. This week what I have in store for you is well known as a result of the syllabus. We will proceed through that section of the chapter this evening. I also have another bar exam fact pattern for you, one that I hope to work in before we're done, although I am going to put a somewhat greater emphasis on moving through the material in the syllabus first before we move on to that. So briefly, let's review together Chapter 3, Privileges. There are a number of different privileges, and the reason for understanding them is to be able to analyze, quote-unquote, the other side of the case. And it's notable that we're using the word privileges here. Technically, it's a word that I don't see used often in actual legal practice. But academically, all of the contents of Chapter 3 are considered privileges. Later on, we will be focusing on defenses. I think of privileges as basically being defenses, because they're arguments that the defendant can offer in order to escape liability. But technically, privileges are not a defense, they are more of a justification. Whereas when we look at defenses, a number of chapters from now, we're going to be focusing on a couple of broad areas, looking at the plaintiff's conduct as a defense, and also looking at technical litigation issues like the statute of frauds as a defense. So the privileges that we refer to have a short list. The first one that we studied was consent. I think the best case in consent was the football case, because that one gives us the clearest idea about the boundaries. I think the case about the injection on the liner, the inoculation, also is a pretty good case. But what the two cases have in common is when you look at the totality of the circumstances, we find that both cases are basically reasonable. There are a number of consent issues relating to medicine and children and medical consent, and of course abortion and underage females seeking the right to choose. I am less interested in the medical stuff because I consider it to be something of a specialty, part of bioethics, part of medical law. But for our purposes, understanding at least the basics of informed consent are part of the core of the class. After consent, the next big category, self-defense. Self-defense is a direct overlap with criminal law, and although I am not currently teaching criminal law, I've spent a fair amount of time in criminal court, and my experience personally is that intellectually, self-defense is basically the same. And the key phrase in my mind whenever I think of self-defense is reasonable force. Under the circumstances, someone who defends himself or herself is allowed to go right up past the edge of using deadly force, so long as it is reasonable. And we also see a lot of difficult factual issues. We know that self-defense is okay, but retaliation is not. Suppose that the defendant is attacked by somebody with a knife, and the first thing the defendant does is disarm the person by knocking the knife out of their hands. Is hitting them after that a retaliation, or is that part of self-defense? And I think the answer is, it depends on the circumstances. There aren't right-line answers to the close cases. We also see that in self-defense, a reasonable mistake is a valid defense. And we saw in just about all the intentional torts, reasonable mistake is not a defense. So in self-defense, we see that the prospective defendant actually has a little bit more freedom, a little bit more wiggle room to engage in conduct that otherwise would be considered wrongful and escape liability. Also, we see in self-defense that the doctrine of transferred intent doesn't apply. Remember, in intentional torts, if you intend wrong against one person and end up hurting someone else, transferred intent establishes the tortious liability of the person engaging in that conduct. In self-defense, transferred intent does not apply. The third privilege that we studied was defense of other. Here the cases are a little less consistent, but that buzz phrase of reasonable force again comes up. But as we saw in looking at the cases, and by the way, if you go deeper into it, the ambiguity gets worse, not better. We see, for example, that mistake does not necessarily destroy the defense of others' defense, but sometimes it does. And if there was a way that I could give you some coherent formula, I promise I would, but I don't know of one. It's a case-by-case analysis. There are a number of cases where the use of force obviously goes too far, others where it's obviously reasonable, but then there are the gray area cases that are really pretty unsatisfactory. The fourth privilege that we investigated together was defense of property. And we started off with Cadco versus Briney, the classic spring gun case, one of the only recorded cases in which a criminal trespasser actually is able to establish a valid tort claim against the landowner. And the reason, obviously, is that the value of life is greater than the value of property. And again, I counsel you to have a look at the instruction number 6 at page 110 of our text, a very good statement about the general contours of spring gun law and other automatic defense of property issues. Similar to defense of property is recovery of property. I think I mentioned last week or a week or two ago that I'm also teaching a paralegal class about torts right now. And in the last few days, I introduced to them Hodgedon versus Hubbard, that ancient case about the stove. The paralegal students were blown away by the case. But the comments that I got from them included, how did they have credit ratings back then? And I suggested that in small-town America 150 years ago, everybody knew each other. And this guy was able to tell his credit story long enough to take possession of the stove, but it wasn't convincing enough for him to get it home. But this case, I think, is very useful, again, because the factual context is complicated. We establish that the plaintiff in the case took away this stove as a result of fraud. We see that the recovery of that property is justified, but what makes it a little more complicated is that during the repossession, the fraudulent buyer pulled a knife on his pursuers, and then they had to use what otherwise would have been excessive force to recapture this chattel. The fact that the person wrongfully in possession chose to escalate the confrontation into something more physical was something that was not put on the defendant. The escalation was done by the plaintiff, and it was enough for the court to characterize him as becoming the aggressor. So when you take a step back, the law pretty much makes sense. You're not allowed to use unreasonable force at all. And if you do, you're going to be subject to tort liability to the victim, and also, as you know from your Monday night class, criminal law may apply to the situation also. The Bonkowski case is relevant in recovery of property because it goes to law enforcement a little bit, although it isn't a publicly employed law enforcement officer in case, it's a store employee. But what Bonkowski establishes is that the privilege that a shopkeeper has extends reasonably beyond the boundary of the store. And again, I counsel you to look toward the bottom of page 117 in the analysis, because the court chooses to incorporate facts from the instant dispute into the definition that it's applying to the case. And I counsel you all to have a look at that, because that's an example of the sort of legal writing that every law school in the English-speaking world is trying to teach. We don't want you to recite a lot of law as boilerplate. We want you to understand the law, but we want to sharpen our analytical skills at connecting or showing a reader where the law and the facts touch and how that contact creates the result that we use. Now, in the middle of page 118, the court is extending beyond the restatement to establish in that jurisdiction that the privilege goes beyond the boundary of the store. And next we turn to necessity, the sixth of the privileges that we studied. And I think all of these cases are fairly interesting, but the bottom line is that necessity allows for conduct that otherwise would be tortious. In the Geary case, we saw a house destroyed in an unsuccessful effort to prevent the spread of fire. We see that this is a situation where law enforcement, official law enforcement, has greater freedom than other people do. The police are able to destroy property without liability, absent a showing of fairly egregious misconduct. Vincent versus Lake Erie is worth being aware of, and it's a case we're going to refer to again a couple of times as we consider negligence. That's the case where a ship damaged a dock during the storm. The owners of the ship were found liable for the damage to the dock. The conclusion in the case at page 125 is actually quite tightly written. And again, I counsel you to have a look at the rare parts of these decisions that are really well written. At the top of page 126 in note 6, we see that the necessity defense has boundaries. Necessity is not a justification for homicide. Self-defense is. Sometimes defense of others is. But the necessity defense doesn't work for homicide. Next, we turn to the seventh privilege, authority of law. And here, again, we've got a degree of overlap with criminal law, and particularly criminal procedure. A law enforcement officer with a warrant, with a facially valid warrant, has the right to arrest, and these are comparatively ministerial. As long as the warrant is valid on its face and the officer is unaware of any problems with the warrant, it is legal. It is privileged. The cop's action is privileged. However, even with a valid warrant, if a sworn police officer mistakenly arrests the wrong person, then there is a likelihood of liability. And there are actually a few recent cases involving criminal suspects that have distinctive Middle Eastern names, where there are several people with the identical name, and police officers arrest somebody with that name who is not the correct person. That actually a couple of those cases provide a gray area that we haven't otherwise seen. But again, when we have these overlap areas with criminal law, I am going to lean in the direction of torts, but I illustrate that there are these commonalities. Next, we consider discipline, and we lead off with the right of parents to discipline kids. I wonder how many of you are aware of the current case involving a professional athlete involving discipline. You see Charles Barkley on TV talking about it? Do you know who Charles Barkley is? A very prominent NBA player who's been retired for a long time. The case involves a player who gave a whipping to his kid that left marks. And the dad got arrested for it, and he's a professional player. And Barkley got on television and said, almost every African-American family in the South whips their kids like this. And as a child of European parents, I faced much more severe discipline than my fellow white students growing up in LA. And so I look at this discipline case, and I want to express some concern about the extent to which government gets involved in family matters. Certainly, I think it is criminal to injure a child and certainly to severely hurt a child. I have never whipped any of my kids. I did bite one of my daughters once, and trust me, she had it coming. But I didn't hurt her. And I think it's wrong to hurt children. But I wonder about where the boundaries of this law actually should be. I wonder if any of you have strong feelings about this. Did that case catch any of your attention? What do you think? He went too far? Uh-huh. So you draw the line at using a weapon? That's right. That's a whipping. A sandal's not going to cut you. Other thoughts? Uh-huh.
He was older. I fought him for taking, I'm thinking that was parents. But also 4 years old.
Right.
I definitely, and I don't think the kid was always the better.
Uh-huh. Well, I'll tell one more quick anecdote. My wife is a very nonviolent person. She's lectured me all our marriage about this, and like I said, I've never been aggressive with any of the kids. But our youngest kid is about to be 16 years old, and she was about 5. My wife and I were talking about this discipline issue, and then a couple hours later, the little girl comes out of her bedroom, which is upstairs, and she looks over the banister, and she spits on her mom. Spat on her. And my wife, Alexis, was on autopilot after that. She went up those stairs, she chased that little girl into the room, chased her from under the bed, and slapped her a couple of times and said, "You do not spit on your mother." And then she came back downstairs all red-faced and angry. I had to laugh. I said, yeah, so the rule is only based on how much provocation you get. And she just said, enough already. Okay, other thoughts?
Well, I remember this was many years ago, but a friend of mine was parents did this guy himself. He had a case, and I don't think it was that severe, as a parent and father. There was Sunday, and my mom and dad were fighting on by the time we said that
Uh-huh.
how do you make that jump and say, you just did it, never
Well, I'm not here to be on a soapbox and tell you what the law ought to be. But this is a public case that's being widely discussed right now, and it's exactly on point. And so I thought it would be worthwhile to at least bring it up long enough to touch on it so that I can prove I at least watch TV once in a while myself. Yes.
In the sports world, I feel like the child, mother, and the father aren't married. Could he, on his own behalf,
Sue him for damages? Sure, of course. And if he pleads guilty to the criminal case, that will pretty much make it. the factual findings will stick in civil court too. And I'm going to leave it at that. It's really tempting to go off on a tangent here because there's a lot of evolving law on this point, and a lot of public discussion about it. Sometimes actually fairly intelligent. Look at page 129 in the middle of the paragraph that starts discipline. There are a number of factors relating to the discipline privilege, and I really think this method of analysis is pretty good. I'm going to read. Factors include age, sex, and condition of the child. So, okay, in this public case, we've got a really little kid who suffered some actually fairly severe wounds. The nature of the offense and the apparent motive. Okay, well, I don't know what the kid did wrong that the dad decided to take the switch to the kid. The apparent motive appears to be discipline, but I think we can all agree that with a kid that small, it's possible or maybe likely that the discipline went too far. Influence of child's conduct as an example to other kids. Well, this is a little child in that case, so that example doesn't make that much difference. Influence of child's conduct, whether force or confinement is reasonably necessary. Notice, or confinement. Well, we've got parents locking kids up in the cellar for 6 years and stuff like that, but a timeout for an hour, is that unreasonable? Again, it depends on these other factors. And whether the discipline is disproportionate to the offense, and whether or not it is unnecessarily degrading or likely to cause serious or permanent harm. Okay, well, anybody who has spent some time studying developmental psychology knows that it's possible for a parent to inflict very severe emotional wounds on a child just by words. And so the discipline statutes often also include psychological abuse, which, by the way, I certainly agree is as reasonable and as true as any of the other forms of violence that we've talked about. That's why intentional infliction of emotional distress is a separate intentional tort. And again, remember, when you hear IIED, the word that should come into your mind is outrageousness. If the conduct of the defendant is outrageous, it's more likely that IIED liability will be established. Other discipline issues include teachers. There are a number of factors to consider with teachers also at page 130. They are similar to those dealing with parents. And then also military. And by the way, the military cases, there's a lot more to it than the chapter indicates. It splits into a couple of categories. Military discipline during training and military discipline in combat. And as you can imagine, the more fresh the recruit, the less latitude there is for harsh discipline. And the closer we are to life and death situations in actual battle, the more freedom there is. My generation knows a lot about World War II because our parents mostly fought in it. Younger people don't. There's a very famous American general in World War II, George Patton, who actually was removed from service as a result of slapping a soldier. The soldier was suffering from battle fatigue. Patton visited the soldier at a military hospital. The soldier started crying or otherwise acting emotional, and Patton slapped him. Said, "Nana," basically. And got in severe trouble for it. And it was widely seen as going far beyond what was reasonable for a commanding officer to do. Then, finally, we considered justification. And we looked at that school bus case where the school bus driver was arguing that his conduct of confining the kids to the bus and driving them to the police station was justified. And the court in that case didn't reach a final conclusion about whether that incident was okay, but did send it back down for trial for that defense to be established or to be argued. And then at the very end of Chapter 3, I directed your attention to the very last note, the very last thing in the chapter, a deprogramming case, where the parents went far beyond what would be allowed any other grown-up to do to a grown-up, and basically got away with it because the nature of the relationship gave them certain privileges to act in ways they wouldn't otherwise. Now, if you recall, back in intentional torts, when we looked at false imprisonment, we looked at a deprogramming case there, and the court very explicitly held that the parents didn't have the right to deprogram. or at least had gone way too far in their efforts to deprogram this one young man. And I point to the two cases as perhaps both being correct, even though inconsistent with each other. But again, these are gray areas that I find to be of particular interest. I'm going to stop this summary and begin the next video to consider our quick review of negligence, which will lead us into the current content.